Well, firstly, thank you very much to everybody. And it comes to me to wrap up after what has been really quite an extensive webinar. My first point is one of highlighting positive change. And in my position, you have to be an eternal optimist to do this job. You certainly don't do it for money. Having established the civil society platform in 2014, when those four words, and I started out talking about those four words, human rights C, were actually limited to academic development and discussion, today, I can honestly say that I am amazed to hear so many experts and attendees speaking and indeed being galvanized about human rights at sea and how we can collectively develop innovative solutions which crucially are victim-centered, thereby empowering individuals who may not have access to employer, flag state, port state, coastal state, or indeed union support. And so today, really, this event has been part of the continuing development of the emerging DNA of not just our charity, but of the wider human rights at sea. And I'll use that word, ecosystem, which itself has made huge strides, bringing this human rights at sea, not the platform, but the concept into common language use across policy, legal, and academic developments. So we're going to continue doing the right thing and publicising it for public awareness. And we note James's points about bringing the shipping industry on side, a challenge that we continue as civil society organisation to face, indeed have faced for the last 7 years, with much respects, generally requires one to be inside the club. But clubs have unwritten rules, and that may not necessarily fit with what Human Rights C and other NGOs are attempting to achieve. So we'll see. It should also be noted that reputable civil society organisations are fundamental to the fabric of society, in pushing agendas into the public eye, tackling difficult subjects and cases, and challenging lack of transparency and exposing impunity or corruption. And we note in terms of this project that success in terms of achieving effective remedy for victims is not going to be achieved just by one route or one entity's prerogative, but by providing multiple pathways which can be adapted in the context of a particular reported incident or human rights violation. So we at Human Rights C, when we speak of abuse and violations, we mean contravening international law norms and establish fundamental rights under the 1948 Universal Declaration, as well as established labour conventions such as the Maritime Labour Convention 2006. And we haven't spoken even about the whole fisheries sector of the ILO Convention 188, the Working and Fishing Convention. But we would say that you can't have a halfway house of dipping one's toe into the human rights pool and then retracting it when one is challenged or matters become a little difficult to either hear or see or read about. For example, most recently, we've been dealing with a murder case in the Pacific in the $22 billion tuna industry, where there's been a lack of transparency, poor access to facts and evidence, and real frustrations with stakeholder engagement. And really for ourselves, the biggest civil society challenges are the corporate and legal veils, which really prevent access to the evidence, the facts. And these do need to be challenged if the case is genuinely in the public interest. These are otherwise we have found being convenient excuses for not disclosing what has occurred in a number of cases that we have investigated and indeed highlighted. So in addition to this arbitration project, if you're not already aware, we're concurrently driving forward with the developments of the Geneva Declaration on Human Rights at Sea, which was issued last year with a second version now shortly to be published, and indeed involving the likes of Professor Petrie. In fact, at the opening of this webinar, I spoke about those four rules which underpin our work, and you may not be aware, but they come directly from the Geneva Declaration's substantive text. So we've also highlighted and seen that it's unacceptable for flag states not to uphold their legal responsibilities, and that flag states must take responsibility. But that's balanced against the complexity of the shipping industry, which we've spoken a lot about. And this provides a key challenge in this project in terms of industry consensus and indeed acceptance or not of the consent to participate. And as I sort of come to the end of my wrapping up session, for us, securing consent for victims of human rights abuses at sea to access the properly constituted arbitral tribunal that can enforce effective remedy, as highlighted by Professor Galliard, is going to be key to our success, and we can't shy away from that. So we aim by next week to ensure that all of these recorded sessions and indeed the presentations provided are uploaded to the Human Rights Sea website alongside all available existing documents. In due course, we intend to develop a landing page as a repository for all aspects of this project, so anybody can download. Finally, I would really like to thank and conclude by sincerely recording my appreciation and our appreciation for the high quality speakers we've had, both of our moderators and most importantly, our attendees. We do hope this event has been of use to you. And I would like to end on and indeed leave you with the charity's call to action, which I hope sums all of this up. And that is the application of human rights throughout the maritime environment at all times and without exception. So thank you very much from me. Be safe and be well.